Okay, folks. Good morning. I hope everyone's having a lovely spring morning today. Um, so today I thought I'd talk a little bit about resolutions, ordinances, and considerations uh, when using one versus the other. So just taking it from the top here, a resolution is a very old form of action by a deliberative body. So our version of it comes from England, as does much of our traditional law. So it's a thing that the English Parliament could do, because of course they couldn't pass laws by themselves. They needed royal consent for that. So this is a practice that deliberative bodies took up over there, which was taken by the colonists across the water and retained by the new American government. So we're talking about a form of action here. The traditional formulation begins with a series of whereas statements. These are essentially factual findings. They are explaining the factual background that the deliberative body is taking into account when coming to its conclusion. And then, of course, you're ending with therefore be it resolved, be it further resolved, be it finally resolved, that sort of thing. So we're making our factual findings, and then we are connecting that to some form of conclusion or some form of action. For folks who are curious, here is a sample. It's up on the website if you want to take a look, but this is just sort of, your classic straightforward resolution style. Now, in law, nothing is ever straightforward. So when talking about what these things actually are in terms of punchlines for you folks, I think it's always important to bring up case law. And we've got, in this case, actually a really neat little case from the Minnesota Supreme Court. So it's a 1965 case, relatively new by township standards, actually. And it's fighting about a bond election for an independent school district. So we've got an independent school district. They wanted a bond. They needed to have an election, and they did have a fairly closely contested one. Of course, this was fairly controversial in its time, as it still is often. In this particular case, it was 181 to 137, but apparently they had a fairly spirited meeting. So everybody agrees that the election was free and fair. The school board in question did in fact have a public meeting at which folks did in fact have the right to be heard. And apparently it got pretty rowdy. They were there for a couple of hours, and the public in the Supreme Court's characterization made their opinions very clear to the board. So our issue here, though, is that, and the reason that I'm bringing this up in this particular case is that, so plaintiff, when they saw these facts, decided, you know what, I don't think you guys had the right to do that because I don't think you followed the proper form. Um, so here's the factual background as stated by the Minnesota Supreme Court. On March 25th, 1963, the public meeting of the electorate was held in the school gymnasium to hear opinion on the possible authorization of a bond issue. After much public discussion, a motion was made that the school board election be held on April 19, 1963. Motion was oral, and it was carried by a 6-1 yes vote. So only one against. Now, the trouble is that the law as it existed at that time was this. So it's section 475.574. And of course, this is what exists at that time, not necessarily what exists now. That section required that proceedings for issuing bonds be initiated by, quote, a resolution, unquote. And that resolution had to set out certain things, the amount of the proposed issuance and its purpose. So what we have in this particular case was just a motion done by oral vote and then recorded in the minutes. So the question is, was the tax increase valid? Did our plaintiff, in fact, owe the extra tax? Now, after hemming and hawing for a fair amount, the Minnesota Supreme Court gives us a pretty clear and pretty helpful definition of what exactly these things are. Technically, a resolution is a formal expression of the will or settled decision of a deliberative assembly, while a motion is usually a proposed action by the assembly. In many instances, however, the statutory requirement of a resolution has been fulfilled absent a formally correct statement by a governing body. Thus, it has been held that a resolution need not contain the statement, quote, "be it resolved," nor need it even be in writing. Generally, where the statute requires a resolution, any official action, though not in form or resolution, may be one in legal effect. So we've got a nice little statement from the Supreme Court that offers us a fair amount of safe harbor when we're taking actions in these cases. That is, they're essentially saying so long as we actually fulfill the substantial bits of extra procedure that are necessary. In this case, we really did have that public meeting. We really did get the public's opinion. We really did set out how much we were thinking about increasing this. So even though we didn't follow the strict formal requirements of a resolution, it was a resolution in legal effect. However, that said, this is absolutely not a get out of jail free card. The critical piece is that even though the forms weren't followed, the substance was. So you've got a fair amount of protection under this case for cosmetic screw ups, but not much in the way of protection for substantive screw ups. So let's talk about why that might matter. So some actions are required by statute to be taken formally by resolution. So we've got some examples here: designating a minimum maintenance road, extinguishing an interest in an abandoned road, or approving a conflict of interest contract. Now, each one of those do use the word by resolution. But critically, they contain some extra procedural steps. And Lindahl will probably protect you if you're not careful about the way in which you record this, but it probably won't protect you if you don't go through the extra procedural steps. For example, the minimum maintenance road process requires not just that you pass a resolution designating it, but you have to set out the starting and the ending points, and you have to put up signage. So if you're careless about the form, that's one thing, but if you're not following the extra procedural substantive commands, you're probably not going to get the additional protections required by this. So probably what you're doing is painting a target on your back.
Sam,
Conflict is in a similar sort of situation.
Sam,
Oh. Sorry about that, folks. Okay. So we've got ourselves, so this is the sample resolution for folks who want to see it. This one's available on the website. I'll be happy to send it to you. Nothing particularly special about this, but as you'll see, we've got our whereas statements and we've got our now therefore, along with our signatures and our adoption, our date, and then our attestation by the town clerk. So this is full formal compliance with the various procedures here. Now, okay. So Lindahl, this is these are our facts, as we were saying. So we've got an election, it's 181 to 137, but they didn't entirely get our procedure quite right. Plaintiff says tax increase was not valid because the board didn't use the resolution procedure. What they did was they passed a motion. Um, but in this case, so this is what the Supreme Court ends up saying. So technically, a resolution is the formal expression of the will or a settled decision of a deliberative assembly, while a motion is usually a proposed action by the assembly. In many instances, however, the statutory requirement for a resolution has been fulfilled absent a formally correct statement by the governing body. Thus, it has been held that a resolution need not contain the statement "be it resolved," nor it need even be in writing. So the question is whether we have followed the substantive process, not necessarily whether we've gotten all of our I's dotted or our T's crossed. But the critical piece of information in Lindahl, as I was saying, is that they did all of the stuff that the statute commanded that they do, even though they called it a motion instead of a resolution. So bottom line here is the law gives you a fair amount of leeway in terms of cosmetics. You might call it that. But when you start dealing in stuff that is more substantial, then you can potentially run into trouble. So we've got a list of things here. So we talked minimum maintenance. That one has some extra procedural stuff on top of it that I'd characterize as substantial. Conflict of interest contract, that's another big one. The resolution one has to be in advance. Except in cases of emergencies, we also have to have it setting out certain facts. So, for example, we have to set out, you know, what sort of interest the person has, whether or not that um, we've taken a look at it and that it's a fair price. So the standard is as low or lower than the goods or services could otherwise be obtained. So in cases like that, you really do want to be very careful about making sure that you're following the proper form, even though we have this statement from Lindahl saying, close enough is close enough, right? Um, okay. Now, the meat of the presentation was supposed to be in the distinction between resolutions versus ordinances. And here, so I've given some examples, some important in terms of the volume of business done by townships. So zoning, of course, is a big one. Criminal penalties, anytime you're adding, potential cost assessments or potential criminal penalties onto something like a road ordinance, that has to be by ordinance. Noise ordinances, that one we've been getting a fair amount of additional inquiries about at the Township Association. Um, but it's not just those. We've got a list up on the website, but you will, or at least I, cannot guess by simple reference to the subject matter whether or not the legislature has commanded this happen by ordinance versus resolution, because there's a bunch of just weird ones. Like if you want to regulate billiard tables, you have the power to do that, but that's supposed to be by ordinance. Dog and cat licenses, once again, you have the power to do that. You need to elect your permission for it, of course. But that one's supposed to be by ordinances. My personal favorite is cesspools. You can regulate that one, and that's supposed to be by ordinance. I don't know what these things have in common. I'm not sure that anybody does. I think it just depends on whether the legislature was particularly mad at townships or cities or municipal governments on that particular day and wanted them to jump through some extra hoops. And the reason I'm bringing this up is because ordinances do involve extra hoops. And these hoops are not simply they're not simply cosmetic. So most of them come from Chapter 365, but there are extra ones in hiding. So we need a specific style, or an ordinance must have a title and must begin with words like the Board of Supervisors of the town of blank ordains, signed by the chair, attested by the clerk. Here's a big one: must be published and posted. Now, in addition, we're supposed to record these things at the clerk's office, and we're supposed to record them at the county law library as well. And here is just kind of a classic example. So this is our model ordinance format going way back. But we've got our ordinance number, we've got our title, we've got our enacting clause, we have the body, we have some definitions, and at the end we have our signature and our attestation. Now, ordinances particularly are subject to this. And once again, this is not a thing that has any sort of organizing principle to it, really. It's just kind of case by case. The legislature has decided to add additional hurdles to these things. So I've collected up a couple of examples that are reasonably common in terms of extra procedural hurdles, but the big ones are zoning. So zoning ordinances must have a public hearing and they must have proper notice. They also have to be filed with the county recorder's office, but that's not the only extra procedural hurdle that's out there. Feedlot ordinances have to be sent to the Department of Agriculture. Burning ordinances, we can regulate the burning of vegetation on our roads. But if we do that before it's effective, it has to be sent to the DNR. So what happens if we mischaracterize these things? We've got a sort of a classic modern case is the city of Waconia versus Doc. And this one's kind of entertaining on a couple of levels. So this is a case about docks involving a family called the Docks. That just feels like somebody feels like an entertaining little coincidence. But the basic fact pattern is this. So 2017, the docks, that is the family, starts beginning to build a year-round dock. They've got lakeshore property in the city of Waconia. Somebody at the city is mad about this for whatever reason. They want only temporary docks, and they decide that they're going to enact Ordinance 705. That's an interim ordinance prohibiting the construction of any permanent docks. And then in 2017, they enact a permanent one saying, no, you can't have permanent docks at all. Now, critically, they don't characterize this one as a zoning ordinance. So they did not follow the extra procedural steps that we just talked about. So the filing with county recorder's office, the adopting only after a public hearing and proper notice being given. And so the Supreme Court ended up drop kicking it. So because the city failed to comply with the extra procedural requirements of 462.357, including notice in a public hearing, it is void. And the permanent injunction, so they won below even. And to just give you a little bit of inside baseball on this, in general, if you win below, the Minnesota Court of Appeals and the Minnesota Supreme Court, their reversal rate is about 30%. So the key to winning at the appellate level is winning below, meaning that these plaintiffs beat the odds on this one. That's how mad the Supreme Court was. So the ordinance was void and unenforceable against these people because there were these extra procedural hurdles that were not cosmetic, they were substantive, and therefore the ordinance was no good. Now, critically for our purposes, the Supreme Court has held that publication is substantial, meaning that this ends up being kind of a trap for the unwary if you're not careful about these things. So we have not just Lindahl, but we also have Davies versus Village of Medelia, which is a 1939 case, but basically saying a resolution passed with all the formalities of an ordinance is close enough and enforceable as an ordinance. But once again, critically, that was a case where the village in that case actually did all of the steps associated with an ordinance, even though they called it a resolution. So as a practical matter, if you're not paying close attention and you're accidentally passing something that has to be by ordinance as a resolution, you are likely to step on dock. That is, you're not likely to remember that you're supposed to publish and post this thing. You're not likely to remember that you're supposed to be recording this thing at a particular place. And so even though you've got leeway in terms of what you titled this document and the form in which it takes, if you're not taking those extra steps, you're likely to run across dock and you're likely to potentially look at something. Likely potentially looking at a defeat if that one comes up for review. Okay, let me hop into the comments here because I saw quite a few. I apologize for the technical hurdle earlier. Let's go ahead and check. All right, can an ordinance provide for a civil penalty? Yes. Yep. So there are a couple of ways that you can do. So administrative fines are one way to do this. The big one is 366.01 says up to misdemeanor plus cost of prosecution. So up to $1,000 fine, up to 90 days incarceration or both. But civil fines are also potentially available under that power as well. And in fact, that would be sort of the more common way to handle things like a road administration ordinance, doing a correction order or something like that. Handling it under civil court would be more common. Do all ordinances require a new number? If the ordinance is amended, what process? So in general, anything that you do, you can undo so long as you use the same level of formality. So, or you can undo it, you can change it so long as you follow the same level of formality. Meaning, all of those formalities that we were talking about earlier, you got the title, you got the number, you got the recording, all that kind of stuff. If you do it again, then you can change it. In the case of ordinances, the basic idea is due process. In this country, we have due process of law. One of things that means is that we have to have a fair chance to know what law applies to you, meaning that you don't get to take out these big guns in terms of the criminal penalties or in terms of the civil penalties, unless or until you're following these requirements. That is, we're publishing the thing, we're putting it in the town clerk's office, we're putting it in the county law library, so that folks who want to know what laws apply to them have a fair chance to go find it. That's true for amendments too. So you go through the same steps that apply, and in particular, if you're dealing with, and that includes, by the way, the extra steps associated with whatever activity you're doing. So I can amend a basic road administration ordinance just by following the standard formalities. So, we've got our majority vote, we've got our proper style, we've got our proper recording, we've got our publishing, we've got our posting, we've got our recording in the proper places. But a zoning ordinance, if I do that, then we're walking into doc. That was kind of what doc was doing, right? Because they're changing these requirements, but they didn't do the proper notification for the hearing, and they didn't do the hearing, meaning that it was ineffective, meaning that it was voiced. So, couple of questions. So, new number. Uh, if you're amending something, yes, it should have a new number, but the bigger deal is making sure that it's codified and making sure that it's available in the clerk's office and the county law library. Um, can a resolution be reversed by a supervisor's vote? Yeah, same principle. Anything that you do, you can change with the same level of formality. Now, there is some additional wrinkles when you're talking about reversing something. So under certain circumstances, if your resolution was legally effective, or even an ordinance, it can grant certain substantive rights to people, then you got to be a little bit more careful. There are some potential extra considerations here. So, for example, in the zoning context, you say you change your zoning ordinance, right? And once upon a time, what I was doing, my junkyard was legal, but now if I was applying for it, it would be illegal. Well, in that case, I get a special status because I was already doing it, so I'm grandfathered in. So, there are complications to this, but the general rule, yes, you can reverse it by the same process that you used in the first instance. Now, Christine has that second question. Where do you find what type of ordinance you should have? That is the $10,000 question. The legislature is not very consistent about what it is or when it is that we should be using these things, and what tools we should be doing. They really like to hide them in all sorts of weird and random places. But we've got a document of that lists most of the big ones anyway. So I'll go ahead and share this for you, and hopefully this time we will be doing it right. All right. So this is Appendix B for TP 6000. This has got the statutes that talk about each of these individual activities. It's the most complete list that we've got. The legislature is kind of always adding to these, and they're hiding them in weird places. But if you want to check, this is a good first port of call. If you're extra concerned about it, please feel free to give us a call, shoot us an email. We'll take a look at see if we can find what specific activity that you're potentially thinking about doing, if there's any special rules about that one. But it really is a case by case basis. As I mentioned at the top, there's no real principle underlying when the legislature says you're supposed to do something by ordinance versus resolution. They just kind of pick it kind of out of a hat, unfortunately. Are we okay publishing a summary of a 7-page ordinance? That's a great question. Yeah, let me show you the authority on that. Uh, the authority is 365.125, and here it is. And so the answer is yes, you can publish a summary, but there's special rules for that. So the town board must approve the words in the summary. The decision to publish only the title and a summary must be made by a 2/3 vote of a 3-member board or a 3/5 vote of a 5-member board. This is a real weird requirement, but that is the way that they have described it. I'm not sure what they think the difference between a 2/3 majority and a simple majority is in the case of a 3-member vote, but there you are. So you have to approve the words in the summary. A notice must be published with the summary. The notice must say that a printed copy of the whole ordinance is available for inspection by any person during the clerk's regular office hours or and at another named place. Um, so the idea here again is that we are making it possible for people who want to understand the law as it applies to them to they got a fair chance to come read it themselves and understand the whole thing. So the summary is supposed to be a fair and reasonable notice for a person of average intelligence about, hey, look, your rights may be affected by this thing. It's now time to go down to the law library or go down to the clerk's office and take a look at these things. Different subject. When does a person doing service for a township need a certificate of insurance? I mean, so it's a question of appetite for risk. If they're an employee, workers' comp coverage is there you go. If they're a volunteer, you can get away with, a volunteer services agreement, which says, "Hey, look, I agree that there's a certain amount of risk involved in this. However, if you screw up, there is always the Tort Claims Act, right? Which is you're running the risk that that disclaimer is not going to be found to be valid, and then potentially we'd be looking at liability for the township, in which case you've wanted them to have insurance. So it's not like there's a statute saying you must have it under most cases. Certain contractors have to have it, but those rules are fairly detailed, and I don't have them off the top of my head. I don't want to misstate them, so shoot me an email if you want a reference to that statute. Um, but for cleaning the town hall, for example, that's mostly we recommend anytime you have a contractor that you get that 1.5, and that's just coming from the Tort Claims Act as the maximum amount that could possibly be imposed on the township, which is silly on a couple of levels. We know that, we understand it, but that's what the legislature has sort of chosen to do, and that's where that recommendation comes from. Um, so there you go. Okey doke. Well, folks. Thank you very much for your time and your attention. Do appreciate you coming out this fine Tuesday morning. Now, at the legislature, I can tell you there's some rumblings. So please do pay attention to your email. We might be sending out a voter voice on something fairly soon. I don't want to step on our toes here exactly, but what we saw a bit of we had a bit of an ambush at the finance committee yesterday, and we're trying to figure out sort of what to do. Are there Minnesota statutes regarding resolutions? Yes. So once again, this is a situation where it's kind of a case by case basis. We don't have one that is the equivalent of the ordinance statute that I showed you earlier. It's more like, let me show you here. I'll just grab a couple of examples here. And kind of give you a sense of what of how the legislature tends to handle these things. Okay, so let's share the screen again. Just a moment. All right. So what they tend to do is to say this has to happen by resolution, and also the resolution has to contain these certain things. So a great example here is the minimum maintenance road one. So we need a determination that the road or road segment is used only occasionally or intermittently, but the resolution must identify the beginning and end points of the road being designated. And then, of course, we've got signage too. So they say we have to have this resolution, and we have to identify it must contain the identity of the beginning and ending points. Now compare that with this one. So 471.89. This one is the one I was mentioning earlier. That is you're doing a conflict of interest contract for something that is below $175,000. So in this case, the what must be in that resolution is much more detailed. Um, shall authorize the contract in advance by adopting a resolution setting out the essential facts, determining that the contract price is as low or lower than the price at which the commodity or services could otherwise be obtained. And then, of course, we've got these extra. So in that particular case, we have a time that we need to do this. It has to be before the contract, not after the contract. We have content that needs to be in there. So we set out the essential facts, and we have a determination that needs to be in there. That is, we are getting a price that is as low or lower than we would otherwise get if we open these things on the free market. So it's really a case by case kind of situation, and they change it based on it's kind of Calvin ball. They change it based on the subject matter that we're dealing with. County is gearing up for elections. Does the township have any new updates for 2026 elections for supervisor seats? So there were some changes to the elections last year. Let's see, I've got a list of them that that got passed last year. Um, I don't want to misspeak here. Nancy, let me send it to you when we're offline. But they changed some of the deadlines were extended. Some of the periods were changed. I mean, they're always monkeying with this stuff a little bit. So yeah, there are some updates, but it's detailed enough that I'll send it to you. So Crystal Bay, all right. Why don't you guys toss your email addresses into the chat, and right after this, I will throw it. I'll shoot you an email. Alrighty. Okie dokie. Alrighty. Got the list. Okay. Well, folks, happy to answer anything else more. The slides be available to print out. I mean, if you'd like these slides, I'd be happy to send them to you. Um, let's see. Yeah, I can say is it PDF work? Save it that way. Um, otherwise, we can do a little bit of condensing. Some of the images are a little big. Okay, I'll send you a PDF.
And as it, Graham, and as a reminder to everybody, the recording of these calls with the video is posted on the Matt website, usually about a day or so afterwards when we get all the files. So you can find it on the Township Tuesday page on the Matt website. All the calls, all the things, all the videos, all the presentations. Yeah.
Thank you for that reminder, Leslie.
Yep.
All right, folks. Well, thanks very much for your time and your attention. For those of you who please just let me go ahead and repeat this one. I think we might be doing a voter voice thing. It's a Government Data Practices Act issue. I don't want to step on our toes here. We're sort of talking to folks still, and I don't want to jump down their throats when we're still potentially looking at solving this thing amicably. But it's yeah, just be on the lookout for that one. And if you see it, please do flag it for your other members of your board because this is a potentially if it goes wrong, this could be a big deal. But just pay attention to voter voice, and if you send it, and if you see one, please do tell your friends, tell your other board members because voices matter a lot in this context. So, all right, folks. Um, thank you very much for your time and attention, and I hope you have a wonderful Tuesday morning.
Thanks, Graham.